I swear I'll slap you right in the face. Say that again and you'll regret it.
By the way, congratulations on your YouTube channel.
I'm sorry, what?
Congratulations on your YouTube channel.
Thank you. Oh, don't play favors with the court,
No,
okay?
I'm not that.
So here's the thing, and this is just for me to make sure that the legal system is transparent. The legal system should be transparent. Everybody should know what's going on
Yes, ma'am.
with the court system. Good morning. All right, court is calling 2022 CR 2485, State of Texas versus Luis Mora. Could I have parties announced for the record for the state?
Jason Garrett, and Your Honor.
Defense?
Jay Moritz, Your Honor.
And are you Luis
Yes,
Mora?
ma'am. Sure.
Are parties ready to proceed on the motion to revoke?
We are, Your Honor.
Yes, Judge.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
Yes, ma'am.
And did you understand it?
Yes, ma'am.
Are you the same Luis Joaquin Mora who was placed on deferred adjudication in 2022 CR 2485 for the offense of possession of a controlled substance penalty group 1 gram to 4 grams on April 14th, 2022 for a period of 3 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violated condition number 4, in Dare County, Texas, the defendant Luis Joaquin Mora, the defendant failed to report to the supervision officer as directed for the months of January, February, and March 2024 in violation of condition number 4.
How do you plead to that? True or not true?
That is true, ma'am. Yes, ma'am.
Your Honor, we'll waive the
Any objections?
No objections, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine?
I understand. Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4? Court will find violation of condition number 4 true. The court doesn't have a trial court certification.
Okay, they're withdrawing the motion. You're gonna go adjudicate? Okay. Oh, I'm sorry, Judge.
No problem.
By the way, congratulations on your YouTube channel.
I'm sorry, what?
Congratulations on your YouTube channel.
Thank you. Oh, don't play favors with the court,
No,
okay?
I'm not that.
So here's the thing, and this is just for me to make sure that the legal system is transparent. The legal system should be transparent. Everybody should know what's going on
Yes, ma'am.
with the court system.
Yes, ma'am.
And this channel is through the government,
Of course.
through the state of Texas. It's not my channel.
No, I understand.
right.
It. I understand it.
All right.
This is a revocation of your probation, okay? And if the judge revokes you, you do have a limited right to appeal.
Yes.
All right. So is there a proposed agreement?
There is, Your Honor.
Yes.
It is to deny the motion and continue on deferred, extend the individual for 18 months, and then for DDRF, and then state ISF, a substance abuse track, should he not meet the criteria for DDRF.
All right, so why is he not reporting? You want to raise your right hand for me? Do you
don't-
solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, lower your hand. Why are you not reporting?
I had gotten a hypertension pulmonary lung disorder, and they kept me in the hospital for a month because I was going through a divorce. So then after I got out of the hospital, I got scared.
So when were you in the hospital?
If I'm correct, it was January. No, right after I was done reporting. It had to be June, if I'm correct. January, June, one of those.
So June.
I think it was June. Yes, ma'am.
All right, so you were in the hospital
For a whole month.
for a
yeah.
month, the month of June.
Yes, ma'am. And then they wouldn't let me out. And then when I got out, I was so scared.
When did they release you?
It had to be around July.
All right, so
July-
you were
July
released in
20
July?
Like July 29th, if not almost the 30th.
All right, and so nobody's seen you since July?
No, ma'am. And I had gotten scared. That I'm not gonna lie. So I didn't report.
All right, this doesn't make sense to me that he's not reporting since July and he has a reason that he was in the hospital.
I understand, Judge.
So does anybody have proof that he was in the hospital?
Paperwork, but it's not with me. Of course, it's I have it in my file. Works at the house.
Well,
I came from the jail. No, that's why.
no, who else lives at your home with you?
Well, I'm, to be honest, I don't have a home. I just have my paperwork with a friend of mine,
Oh, who's the paperwork with?
Jessica.
Jessica who?
Jessica Ambrodos.
Right. You have her number?
No, ma'am, I don't.
Then how do you get in contact with her?
I was staying there for the moment. They're just like,
Oh, do you know the number to that household?
no, ma'am, she doesn't have a landline.
All right. So here's the thing. If he is saying that he was in the hospital, which I don't know if it's true or not, I need proof of that.
I have paperwork.
What he's pleading true to is not being in, not reporting January, February, and March of 2024.
All right. So,
He's talking about being in the hospital in June, and he quit reporting because he got scared after that.
Yes, ma'am.
is probation here?
Yes, sir.
Yes. Any objection to the court review and the court summary?
Not from the state, Your Honor.
No, Judge.
All right. Could I see the court summary, please?
And we're showing his last report date was December of 2023.
Oh,
So
Okay.
I'm not sure if he's referring to June of 2023.
DDRF.
For his substance abuse issue, and I'm not sure if he just completed, I think he completed a TAP evaluation in December of 2023, and they were recommending.
Based upon the UAs and stuff, Judge, he does have an issue with the controlled substance.
All right. I don't understand. I'm not going to continue. I don't think you're a good candidate for probation. In this court, I always tell people if they need help,
Sure.
let us know. You've been on probation since 2022. And for that time, you've been missing for well over a year. So the court is going to grant the motion, find you guilty. Would you all like to speak to punishment?
See the,
Probation, did he pay the $60 restitution for laboratory testing?
No, Your Honor. He's
All-
paid a total of $56.
All right, I am going to order the $60 restitution for laboratory testing. I'll order the therapeutic community. Doesn't increase the time that you're that you're in custody for this sentence. It will just be able to help you with any drug issues you may have, and it appears that you have drug and alcohol issues based upon the court summary. So have you all been able to discuss a time?
No, I've not discussed that with the state has a recommendation.
All right, state, what is your recommendation?
It's the $3,000, like 5 years.
All right. Defense,
Judge, it's a deferred case. On the criminal history, I didn't see anything. I don't see why. Well, first of all, all the reasons have been, there hasn't been any crimes while he's been out. He hasn't committed anything other than testing positive for the drugs that he's taken for the mental issues that he's got. And that's why he was with the dual diagnosis program to begin with. So I'm looking for the minimum of 2, Judge. If you are still going to sentence to prison, I would like to get him a treatment program to get him into something. But I don't think it fits the needs to sentence him to 5 years.
all right, the court will sentence you to 3 years in the prison, give you credit for any time served. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it?
No, ma'am, I don't think I have, I don't.
Well, so this is what has happened. So I've revoked you.
Sure.
And what that means is because there was not an agreement on punishment, then you do have a right to appeal. That right to appeal is limited though. It's limited to whatever the allegations were in the motion that you pled true to.
Yes, ma'am.
You cannot appeal and say, I'm appealing because I was on deferred adjudication and I shouldn't have been on deferred adjudication.
Yes, ma'am.
That ship has sailed. So you do have a right to appeal, but it's a limited right to appeal. Do you understand?
I don't understand that. May you please explain that to me?
All righty. So anyway, did you sign that document entitled Trial Court Certification of Defendant's Rights to Appeal? Is your signature on that?
Yes, ma'am.
All right. Because this was not a plea bargain agreement, you do have a limited right to appeal. Your attorney will explain that to you. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
I understand.
All right, so we're off the record. I'm requesting the therapeutic community for you. It does not increase the time that you're in custody, but it may help with any issues you may have.
Yes, ma'am.
For the state defense.
Michael Collins, attorney for defendant, present ready, Your Honor.
And are you Mr. Casanova?
Yes, ma'am.
All right, he was found guilty on December 4th
Yes, Your Honor.
by the jury. And he elected to have the court assess punishment. The PSI was waived by defense in the state. Is that correct?
Yes, Your Honor. I did.
They need offensive, wait, yes, I have no objection to moving forward now.
Okay. And so we set it for this time for anyone to present any evidence or if they had any witnesses.
We have no witnesses other than my client, Your Honor.
The state criminal witnesses are really are going to admit, impact into evidence.
Objection.
We are also gonna ask the court to consider all the evidence that was admitted in the evidence.
All right, states exhibits 1 and 2 are admitted without objection and they appear to be judgments. Any other evidence, state?
No.
All right, defense, any evidence?
Just argument, Your Honor.
All right, did you want to call your witness or no?
Let me ask him if he wants to speak, Your Honor.
Okay, sure.
Yes, upon, yes,
Yes, Your Honor. I would call my client.
All right, if you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Richard Thomas Casanova.
All right, do you want to ask questions or is there something
think he wants-
specifically he wished to say?
Richard, do you want to address the court at this point
Uh,
about the punishment phase?
I just want to say that when I get out, I'm not gonna go back to my mom's house or my daughter's, and I'll go to Haven Furlough. And I wasn't aware that I couldn't go, to try to get my mail. I thought that the protective order had expired because it was 1 year and I could never get my mail, so I didn't know what was going on. I was put on the street pretty much. I didn't have no place to go. So
All right, any questions?
No question.
All right, so what I can tell you, Mr. Casanova, the fact that you're telling me that you didn't know about the protective order, that is what's considered as mitigation evidence. These type of offenses are sort of like strict liability. Was there a protective order in place? That's either yes or no. And did you violate it? Yes or no? So that's the way these type of charges are. There are some charges that are slightly different, but not this. Okay?
yes,
All right. State, what are you requesting for punishment?
Given the history judge and the fact that it's not the first violation, where we ask for here's to the scene.
All right, and defense, what are you requesting?
Would be requesting probation in light of he's been incarcerated since the date of the offense, which was late April of 2024, Your Honor, hasn't been in trouble with jail. And he is expressing to the court that he has no intention of going back there, Your Honor. He was under what he thought was a mistaken belief of fact, Your Honor.
I do have one thing to add, he was indicted as a repeater. We're just gonna ask for the judge mind touch from that.
All right, so let me see the indictment. And you're proceeding on the repeater enhancement allegation?
Yes.
All right, Mr. Casanova, you're still under oath. I'm going to read the repeat offender enhancement allegation paragraph, and I need to know from you if it's true or not true. And before you answer, you can discuss that with your attorney. It states, and it is further presented in and to said court that before the commission of the offense alleged above on the 24th day of June AD 2010 and cause number 2007 CR 2886 in Bear County, Texas, the defendant was convicted of the felony of criminally negligent homicide with deadly weapon. So the question is, how do you plead to that, true or not true? And you can speak with your attorney before answering.
true.
Right. Then the court will find that true based upon your plea of true and based upon state's exhibit number 1. What the court's understanding is that this location he went to, is that the daughter's house, mom's house, his house? It appears that during the testimony, he was saying that's his actual place of residence. I know sometimes when there are violations of protective orders that are filed, whoever they deem to be the offending party, they make them leave, whether their name is on the property or not. So the persons who were at the home, what I remember from the testimony is it was his daughter. Is that correct?
Correct, Your Honor.
Yeah, Judge.
So is this protective order involving the daughter, that location, and his mom?
Daughter. I would have to check to see if there's any other parties that are protected, but I believe it's.
That's the only one that was unprotected.
So here's my question.
Daughter and the rest, and that address.
Yeah.
So here's my question. Has anyone spoken to the daughter?
So I can inform the court of what the daughter told me, but of course I don't know how.
Well, do you want to speak to the attorney before?
Then one of our investigators went over to the address to make sure that somebody was present. We have called her multiple times, texted her, she had not returned her calls until one of our investigators went to the location and found her. She called me, I spoke with her. I did explain to her about the case, about being in trial and her coming over to present her testimony, and she did indicate to me that she did want to testify. However, she could not make any arrangements because she is the caregiver of her grandparents.
Mhm.
And she could not make coming to court for that. We did make efforts to reach out to her over the phone. We confirmed that that was the correct number that we had. And after the guilt innocence, we did try to inform her about her coming over to testify during the sentencing, but she has not returned our calls. I have not sent out an investigator to her location again.
All right. So part of the consideration the court takes into consideration, or evidence that the court takes in consideration, especially in this case, one, of course, is protecting the community, and two, protecting the parties of the protective order. Now, sometimes family relationships between fathers and daughters, fathers and sons, mothers between their children as well, it's difficult. So what I would like to know, if it's possible, if it's not possible, I'll make my ruling without this information. But if you all want to just try again today, state you and the defense counsel to reach out to the complainant, find out if she has any fear of him, and what her thoughts are on sentencing. And then I'll make my ruling, but I'll make my ruling today.
As long as I can be present on the conversation.
Yes.
If we aren't able to get a hold of her today, I just want to make sure with defense, if you have any objections, we can bring her on Zoom.
No,
Okay. All right, let's try to do that. I want to make the right decision on punishment, okay?
the caveat, I'd like to be able to handle it sometime today because I start vacation tomorrow.
No, we're starting it today.
I just.
So it's gonna happen
Okay.
today. If she
I was gonna-
appears, she appears. If she doesn't appear, she doesn't appear.
Can we have 5-10 minutes?
Sure. This is just information I would like to have.
It's fine.
All right, thank you.
Have a seat.
Let me just grab your file.
Oh, okay.
Here we are. All right, we're back on the record, and 2024 CR 007-360-02 State versus Richard Casanova. All right, State, did you have a chance to reach the complainant?
We have Judge, we have not successfully reached the complainant. Our victim advocate did come down earlier, and while defense was present, she did make 2 phone calls to the number that we have for the complainant. There was no answer. She did leave a voicemail informing the complainant to call us back for the next 5-10 minutes. As the court asked some questions, we did offer appearing over Zoom as a possibility, as an option in the voicemail. She also sent a text message, but that was more than 10 minutes ago at this point, so we have not been able to.
All right. So and are both parties still wishing to proceed without the input from the complainant state?
At this point, Judge, it's pretty clear that the complainant does not have any part of the session.
All right, defense?
We proceed without.
All right. So what I can tell you, Mr. Casanova, I don't think that probation would be appropriate in this case. I have to consider your entire history. It's not just this one incident. All right. So then the question becomes, the state is requesting 8 years. What are you requesting?
I request a minimum, Your Honor, 2.
Okay. All right. This is what the court is doing. The court is finding the enhancement true based upon your plea of true and based upon states exhibits 1 and attachments. The court has heard all the evidence in this case. Based upon the evidence that the court heard, I understand the nature of protective orders, but it doesn't appear that from the testimony that the court heard, that the defendant was there to be violent, that the defendant was there to cause a disruption. The only testimony that the court heard was that he was there to collect his mail. And the testimony that he gave sounded believable to the court and sounded credible. Because otherwise, why would he just be waiting, if not to pick up his mail, as he said? But we're not allowed to be at the residence. You understand? All right, the court is going to sentence you to 3 years in the prison, give you credit for any time served. Let's see. All right, I don't have your trial court certification in here. You may have filled it out,
I did.
but it is not here. So do you mind filling out another one for the
Yes, sure.
court? And then I'm also, as a part of your sentencing, I'm going to order no contact with let me see. I don't have the state's exhibits here. Who is the
We're still with the C, Kasanova.
there's to be no contact with Crystal Casanova. Do you understand?
Yes, Your Honor.
That's from here till eternity. Now, if she decides that she wants to see you, then you all will need to file motions with the court and ask that that be removed. Do you understand?
Yes, Your Honor.
So any location where she may be, you're not allowed to go there. Do you understand?
Yes, I do.
Whether it's your house or not your house. If it is your house and you feel as though you have a right to be there, that's something that needs to be settled in the court of.
This sentencing hearing is more complicated than it looks. Richard Kasanova has been found guilty of violating a protective order, and the judge knows he has a prior felony for criminally negligent homicide. He claims he thought the order expired and just wanted to get his mail. But the rule is simple. If the order exists, you stay away. Before choosing punishment, the judge pauses to try and contact his daughter, the protected person, to see if she feels afraid. If you were her, what sentence would you want? Comment below, and don't forget to like and subscribe for more courtroom breakdowns.
Well, 1:30-ish. Ish, yes.
Mr. Gonzalez is just restored, Judge.
All right. Good afternoon, or, yeah, good afternoon.
Good afternoon.
How are you feeling today? It's not a true question, I promise.
It's a lot better,
Oh,
I
that
gotta
is good.
say.
Yeah. All right.
All right. All right. Court is calling 2024 CR 4541 and 2024 4494 State versus Rudy Gonzalez. Can I have parties announced for the record for the state? Defense.
Bridget Garza.
And are you Mr. Gonzalez?
Yes, ma'am.
Counsel, in each of the cause numbers, have you received all discovery and reviewed that with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. And each cause number, Mr. Gonzalez, did you review the true bill of indictment with your attorney? And did you understand it?
Yes, Your Honor.
Counsel, in each cause number, do you waive the reading of the indictment?
Yes, Your Honor.
State, in the cause number ending in 4-1, are you proceeding on the indictment as presented?
You are, Your Honor.
And in the cause number ending in 9-4, are you proceeding on the indictment as presented?
No, Your Honor. We're waiving count 1 and the enhancement paragraphs and just proceeding on count 1. Can I say count 1 in the first one?
Yes.
Waiving count 2.
Okay,
I just realized that step right there. And proceeding on count 1. And that's the third degree theft, 30,000 to 150,000 vehicle, Your Honor.
all right, any objection?
No objections, Your Honor.
All right, and the cause number ending in 4-1, you're charged with burglary of a habitation, and the cause number ending in 9-4, you're charged with theft, 30,000 to 150,000. Those documents that have those charges in it, it has in there your rights and certain things that you're giving up by entering the plea bargain agreement in each of these cause numbers. Did you review those documents with your attorney? Did you understand them? And did you sign them in all the appropriate places? All right. And the cause number ending in 4-1, the range of punishment is 2 to 20 years. And the cause number ending in 9-4, the range of punishment is 2 to 10 years. If you have a plea, I don't have to follow that plea. If I don't follow your plea and give you more than you bargained for, you can withdraw your plea. And this can be set for trial. Do you understand? Do you understand in each of these cause numbers, you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand by entering these plea bargain agreements, you were giving up those rights? And did you intend to give up your rights and enter into a plea in each of these cause numbers? Did you intend to give up your rights and enter into a plea bargain agreement?
Yes.
All right. Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does now, Your Honor. Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
And it's the court's understanding that competency was restored?
Yes, Your Honor.
Mr. Gonzalez, has anyone threatened you to get you to enter a plea in these cases? Anyone coerced you or forced you to enter into these pleas? All right. Anyone promised you anything other than the plea bargain agreement? Are you satisfied with the way you've been represented?
I'm satisfied. Yes, ma'am.
All right. Are you a U.S. citizen?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In the cause number ending in 4-1, according to the agreement, punishment is to be assessed at 8 years. There's a $2,000 fine. This will run concurrent with the cause number ending in 9-4. There's going to be restitution to Vakata, VENKATI, Lecareddy, LAKKIREDDY of $500. The state will take in consideration 2024 CR 4493, 4066, and 2023 CR 7253. And the cause number ending in 9-4, according to the plea bargain agreement, punishment is to be assessed at 8 years in the prison. And this is running concurrent with the cause number ending in 4-1. And there are no applications in either of the plea bargain agreements. Did you understand that to be your plea?
Yes, Your Honor.
Defense is at the plea?
It is, Your Honor.
State is at the plea.
It is, Your Honor.
And each cause number, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yeah.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there been any such motions?
No, Your Honor.
All right, then in cause number 2024 CR 4494 to count 1, how do you plea? Guilty, not guilty, or no contest?
Guilty, Your Honor.
And then in cause number 2024 CR 4541, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
State any evidence.
Your Honor, in each of the cases, state exhibit that all involved with that.
Any objections?
No objections, Your Honor.
And each cause number, did you review a document? And that document is the stipulations. It has the police reports in it. It has witnesses' statements. Basically, the evidence that the state is submitting to prove you guilty beyond a reasonable doubt. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, Your Honor.
All right. You do understand that you do have a right to a jury trial. You understand that? All right, so that would mean that witnesses would come in, the state would call witnesses, and those witnesses would testify, and your attorney would get a chance to ask them questions, and nobody could force you to testify. Did you understand? So today, the state is just going to present those witnesses by presenting statements that they've given to the police and police reports. Did you understand?
Yes, Your Honor.
In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. Guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. I've been representing Mr. Gonzalez for over a year. And now that he's been able to get some treatment for his mental illness, he's had a clear head. He's pleading guilty because he is guilty. He is remorseful. He takes responsibility. And he wants the court to follow the recommendation of the ADA. He does have a drug problem. He recognizes that. And he understands that when he's in prison, he's gonna have time to reflect on the poor choices that he makes. He's gonna try very hard when he gets out to try to stay off the drugs that caused him to be before the court. And so he's asking the court to follow the recommendation of the ADA.
All right. All right, and the cause number ending in 41, the court will find you guilty, sentence you to 8 years in the prison, give you credit for any time served. There's a $2,000 fine, time and money to run concurrent. This will run concurrent with 2024 CR 4494, taking consideration 2024 CR 4493, 4066, and 2023 CR 7253. There's to be restitution and no contact with Venkata Lekareddy, and the restitution amount is $500. And I'll order the therapeutic community. The therapeutic community doesn't increase the time that you're in custody, but it may be able to help you with any issues you may have. Do you understand?
Thank you. Yes, ma'am.
You're welcome. I can't force you to be in the program, and I can't force them to put you in the program, but they'll see on the judgment that I'm requesting it. You'll still have to ask for it. You're welcome. And the cause number ending in 24. The court will follow your agreement. The court will find you guilty as previously stated, sentence you to 8 years in the prison, give you credit for any time served. This will run concurrent with 2024 CR 4541, and I'll ask for the therapeutic community. Is there anything else with regards to sentencing in each of the cause numbers, state or defense?
No, Your Honor.
All right, in each cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorneys? Did you understand it and did you sign it?
Yes, Your Honor.
All right, because these are plea bargain agreements, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we can go with the record. Here's the thing. Make sure that you ask for the therapeutic community. It's there to help you. Like I said, it's not going to increase the time that you're in custody. If they are planning on releasing you in 2 years, they're not going to say, oh, he hasn't finished therapeutic community. Let's not release him. That's not the way it works. And when you're released, if I'm still here and you can't find a place to stay, or you can't find, Center for Healthcare Services, just come in and I'll pick up the phone and call somebody, okay?
Yeah.
You can't stay with me, but I'll find a place for you, okay?
Um,
All right, good luck to you, okay? You're welcome. Have a good day.
Back in 2004 when he was granted the pardon. So what counsel is saying that we can ex post facto apply the 2015 law to my client, which is untrue.
Your Honor, may I briefly respond?
Yes.
I am making reference to Article 42.12 that was in effect June 13th of 2001, which contains this judicial clemency exclusionary language. I'd also like to point out that judicial clemency is distinguishable from pardon, which Mr. Robeson has not received.
All right, so first question, was it a pardon or was it clemency?
It was a pardon. It was dismissed.
Respectfully, Your Honor, if I'm informed correctly, a pardon is something that is issued by the governor. And this order was not issued by the governor. It was issued by the judge of the court.
Offense, past offense is excluded from not being used in this indictment. He's saying that under chapter 42, that DWI is one of those offenses that are excluded as far as whether or not it can be used for enhancement to provide jurisdiction to the felony court. And you're arguing that's not true?
I'm saying it's not true in this case because the judge allowed him to withdraw his plea and dismiss the case. And it works as an acquittal under Cuellar.
Then why does it say, and State, I understand your argument, but then why does the document say that it can be provided as proof
No,
if he's convicted of any criminal offense to the court? If someone is pardoned, then it doesn't come back as proof that you're convicted of an offense.
it doesn't say that it's proof. It's in her order. It just says that the judge could be informed of the existence of the prior judgment. It doesn't say it's proof.
No, it says, and what I'm reading, it says it is therefore ordered. And then towards the end, it says, he is released from all penalties and disabilities resulting from the crime of the offense, except that proof of said conviction. That's what it says.
Except proof of conviction.
Of said conviction shall be known to the court should the defendant again be convicted of any criminal offense. Now, I understand what the state is saying with regards to chapter 42, but defense, you haven't addressed the issue. The defense is saying that, the state is saying that chapter 42 has been in effect since 2001.
Yes.
The part of the statute, the part of the code that he's reading from. Your client's conviction of this offense was this looks like January 7th, 2022. So wouldn't chapter 42 encompass this, since this conviction occurred after? And
2002.
yes, and the order discharging him from community supervision was signed by a judge in 2004.
Or
And the conviction date, it looks like it's 2002. State is saying that code section 42 is from 2001.
that's when I believe that's when it went into effect.
So then if you agree that chapter 42 is from 2001 and that a state is saying that DWIs are not covered by the exhibits that you've submitted to me, then the state would be correct.
Well, it says the language that it uses is that the case was dismissed. And that the judge allowed him to withdraw his plea. So it is no longer final conviction. So in this instance, the language of the judge caused it not to be a final judgment. And I think under those circumstances, under the Cuellar case, that means that it can't be used for enhancement of punishment in this case. It's not expungible according to the statute, but it can't be used for enhancement. And that's what Cuellar says.
All right, State, are you prepared to address Cuellar? Or do you need more time?
So, Your Honor, as far as I can tell, Cuellar is completely off the mark for this. That was a felon in possession firearm case in which the defendant's prior felony conviction was subject to 42.12 section 28 clemency. And the state argued that
This isn't a normal plea hearing. It's a legal chess match. John Roberson's entire felony case may hinge on one old DWI from another county, a judicial pardon, his lawyer says wiped it out, and a statute the prosecutor says makes that order basically void. The judge is stuck between two readings of the law. Does that prior conviction still count, or did the old judge go beyond their power? If you were on that bench, how would you rule on this enhancement fight? Comment below, and don't forget to like and subscribe for more courtroom breakdowns.